See the mind I wanna stay, feel me you, getting all the piece of pie for your wife. Everybody wanna know how it feels. Everybody wanna see what it's like. Living in a big house, I don't mind. Me and Missy is so the make it money. Alright. Greenback Boogie.
This court is in session to hear the appeal in Freedom General Insurance Maha and Stephen C. and others. The appellant challenges the session court's decision on two grounds. First, the credibility of the first respondent's testimony, and second, the photographic evidence allegedly undermining the claim of a collision. Lead counsel for the appellant, you may proceed.
May it please your Lordship, my name is Ita Nushaira. I appear as a lead counsel for an appellant, and with me, my co-counsel, Nur Farah Nabila. We are here today to address the first round of appeal with concerns the session court judge NRS accepting the first respondent testimony as credible, despite the clear inconsistencies in the evidence. So the central issue for this court is whether the first respondent alcohol consumptions the night before the accident and his subsequent claim of a skid due to slippery road condition should be impact the credibility of his testimony, especially that the first respondent admitted to the consumption alcohol before the accidents and was under the influence when he arrived at the hospital as confirmed by medical report. So we rely on Section 8 of Evidence Act, which govern the relevance of facts that may include motive, preparations and conduct related to an issue in this case. My Lordship, so motive under Section 8, Subsection 1 of Evidence Act, the first respondent's submission of alcohol consumptions before the accident suggests that the potential motive to mislead the court. So under the influence of alcohol, the first respondent may have been less able to recall the true events of the accident and more likely to attribute blame on external factor like a slippery road. This self-serving behavior is a classic example to motive avoid liabilities meaners to reasoning in the case of signing arm against BP. Next, the preparations under Section 8 Subsection 1 Evidence Act. So the first respondent decide to drink alcohol before driving shows a recklessness and negligence preparations for the accidents. It shows in the case of Jurani bin Hussein against BP, the preparings of an act that increase the likelihood of accident can suggest negligence or a recklessness. This preparation diminish the reliability of the first respondent testimony as witness his account and the event to lead the accident. Next, conduct under Section 8 Subsection 2 of Evidence Act. So the first respondent conduct after the accident, his attempt to blame the road for the accident suggests a conscious effort to avoid the responsibility. So his medical report from Hospital Laka shows that he was under the influence of alcohol when he arrived at the hospital, further compromising his ability to accurately precise the recount of the events. So his statement that the accident was caused by a slippery road may therefore be questioned as unreliable due to his impaired state. Additionally, the large report by both first and second respondent raised doubt about the authenticity of their claims. So the first respondent 1 month delay in filing a police report is highly unusual and raised question about his motive to alter a narrative. As for the second respondent, the 9-month delay in reporting the accident coupled with the settlement payment suggests a deliberate attempt to avoid responsibility. My Lord, we humbly pray for this honourable court to reverse the session court decision to accept the first respondent testimony as credible. Take into account the inconsistency in the evidence, the motive, preparations, and the conduct of respondents, and delay in filing their police report. Find in favour the appellants and remake the case for fresh trial or such other relief deemed appropriate for the honourable court. Thank you.
May it please your Lordship, my name is Nur Farah Nabila, co-counsel for the appellant, and today I will address the second ground of appeal that the session court judge failure to give proper weight to the photographic evidence. So this evidence is critical because it clearly shows no damage to the rear of the first respondent's motorcycle, which directly undermines the claim of a collision and supports the appellant's assertion of fraud. Your Lordship, the photographs submitted as evidence clearly show no damage to the rear of the first respondent's motorcycle. The absence of physical damage is highly significant because it directly contradicts the respondent's claim that a collision occurred. Under Section 3 of the Evidence Act, photographs are considered material evidence that the court may inspect. And the principle here is that photographs are objective, physical evidence providing a clear and verifiable record of the state of affairs. In this case, the photographs reveal that the motorcycle was undamaged, which directly challenges the respondent's assertion of collision. Furthermore, Section 101 of the Evidence Act places the burden of proof on the party asserting the claim. In this case, the respondents must prove that the collision occurred, and they have failed to substantiate the claim with any credible physical evidence, particularly with regard to damage to the motorcycle, which is a critical element. And lastly, Section 73 of the Evidence Act permits the court to compare evidence and the principle is that the court should examine the photographic evidence in light of the respondent's narrative, and it will become evident that the respondent's version of events is inconsistent with the physical evidence. This lack of damage raises a critical question. So how could a collision involving the motorcycle occur without leaving any visible impact? Your Lordship. Next, the absence to the damage to the motorcycle also supports the appellant's contention that the respondents acted in collusion to file a fraudulent insurance claim. Section 114, illustration G of the Evidence Act allows the court to draw adverse inferences when a party fails to explain critical inconsistencies. In this case, the respondent's failure to explain the absence of damage to the motorcycle invites the court to infer that the claim is false. If the respondents cannot provide a credible explanation for this inconsistency, the court should consider their testimony to be unreliable. Furthermore, Section 10 of the Evidence Act permits the court to admit evidence of acts done in furtherance of the conspiracy. The principle here is that if there is reasonable ground to believe that two or more persons conspired to commit an offence, their actions in furtherance of the conspiracy are admissible in court. The appellant submits that the respondents conspired to fabricate the collision and defraud the insurer, and this section allows the court to consider their actions as evidence of that conspiracy. Next, under Section 415 of the Penal Code, cheating is defined as an act intended to deceive another for personal gain. So in this case, this section is that the court must assess whether the respondent has acted with fraudulent intent. And the respondents appear to have fabricated the collision in order to secure insurance benefit, which falls squarely within the definition of cheating. Lastly, under sections 120A and 120B of the Penal Code, criminal conspiracy is punishable by law, and the principle here is that the court may find the respondents guilty of conspiracy if their actions were coordinated to commit a fraudulent act, such as filing a false insurance claim. The evidence in this case supports the conclusion that the respondents' actions were part of a coordinated effort to deceive the insurer. Without any visible damage, it is implausible that the collision occurred, and coupled with the appellant's assertion of fraud, this evidence strongly supports the conclusion that the respondents colluded to make a false insurance claim. In conclusion, my lord, the photographic evidence is not just a minor detail. It is a crucial element that undermines the respondent's claim of a collision. The lack of damage to the motorcycle, combined with the appellant's allegation of collusion, casts significant doubt on the credibility of the respondent's testimony. And the Session Court judge failure to give proper weight to this evidence constitute a serious error. And for this reason, respectfully submit that this Honourable Court should allow the appeal, overturn the Session Court's findings, and rule in favour of the appellant. Unless your Lordship has further questions, that concludes my submission.
May it please the court, my name is Manasta, and I have the honour of serving as the lead counsel for the respondent, accompanied by my esteemed co-counsel, Ms. Lakshanya. We appear before this court today to respectfully ask for the affirmation of the decision made by the Sessions Court. The Sessions Court judge thoroughly examined the evidence and found the first respondent's testimony to be credible, reliable, and consistent. This conclusion was reinforced by the corroborative evidence that strengthens the reliability of the first respondent's account. A party in a proceeding must adduce credible and reliable evidence to discharge their burden, and credibility determines the weight of that evidence. Corroboration affects the weight, not the admissibility of the evidence. In Malaysia, Section 134 of the Evidence Act 1950 clarifies that no particular number of witnesses is required to prove a fact. The court may rely on the testimony of a single witness even without corroboration. In the case of Anil Bukan against State of Assam, the court emphasized that a single credible witness can be sufficient for a decision. While corroboration may be less critical in civil proceedings, the case of Kartiani and another against Lee Leong Sin and another highlights its application in civil trial. There, the federal court ruled that the respondent's testimony, being that of an interested witness, required stronger corroboration. In Dato' Mukhtar bin Hashim against public prosecutor, the court stressed that credibility must be weighed, not just the numerical preponderance of the witnesses. Similarly, in this case, the first respondent's consistent testimony supported by the police investigation, which recorded his account including the motorcar's registration number, a medical report from Hospital Melaka mentioning a motor vehicle accident with motorcar, and corroborative evidence from the SP4 establishes the facts of the accident. Additionally, the investigation revealed that the second respondent filed a belated report after paying 500 ringgit to settle the matter privately. While the absence of visible damage to the motorcycle and the delayed police report by the second respondent raised some questions, these alone are not enough to disprove the collision. The first respondent's testimony, backed by medical records and SP4's investigation, remains relevant and admissible. Under Section 134 of the Evidence Act 1950, the first respondent's testimony, supported by these sources, is sufficient enough to prove the accident even without physical evidence of damage. Therefore, we respectfully submit that the Sessions Court judge was correct in finding the first respondent's testimony credible and reliable. We request that this court uphold the Sessions Court ruling in its entirety. Thank you.
If I may direct your Lordship's attention to Section 45, subsection 1 of the Evidence Act 1950, which provides that expert opinions on matters requiring knowledge of specially skilled persons are relevant facts. My Lord, the authors of the medical reports are qualified professionals whose opinions fall within this provision. The medical report from Hospital Naka details 2 instances of treatment received by the first respondent on the day of the accident, indicating injuries consistent with the motor vehicle accident collision. The report from Hospital Pantai Ayakuro corroborates the occurrence of the accident. Together, these reports carry weight, supporting the first respondent's testimony and contradict the appellant's assertion of fraud. My Lord, Section 114 of the Evidence Act 1950 allows the court to presume the regularity and good faith of documents prepared in the ordinary course of business unless proven otherwise. My Lord, in this case, the appellant has not provided evidence to rebut the presumption of authenticity under Section 114 or to discredit the expertise of the medical personnel. As such, the report should be accepted as credible evidence, supporting the first respondent's claims. In the 2009 High Court case of PB Malaysia Sanjan Berhad and Samudra Malaysia Sanjan Berhad, it was ruled that unopposed expert evidence cannot be dismissed unless it is obviously lacking in defensibility. My Lord, the appellants have not disputed the reliability of the medical reports. Hence, they remain unopposed expert evidence, not obviously lacking in defensibility and reasonably supporting the first respondent's testimony. In the 1984 Federal Court case of Sheikh Abu Bakar bin Ahmad against public prosecutor, the Federal Court emphasized the necessity of expert evidence in forming conclusions on technical matters. As Abdul Hamid said, it would be erroneous for him to form a conclusion on a matter which could only be properly concluded with the aid of expert evidence. My Lord, the determination of whether the injuries were consistent with the motor vehicle accident required the medical expertise provided in the reports. The Sessions Court judge appropriately relied on these reports to conclude that a collision occurred. For the reasons given, my Lord, the respondents respectfully submit that the unchallenged medical reports conclusively support the occurrence of the collision. We humbly pray that this appeal be dismissed with cause. Unless the Lordship has any further questions, that concludes my submission.
Counsels, you may begin your rebuttals.
My Lord, the respondent argued that the medical report corroborated the first respondent testimony, but this overlooked the critical lack of physical evidence. Photography of motorcycle reveals no damage to its run. Direct contradicts the claim. They have not provided credible explanations to the absence of damage, which raised serious doubt. So the appellants pray this honourable court overturn the Session Court decisions to find in favour of appellants. Thank you.
My Lord, in addressing the appellant's rebuttal, the respondents submit that the medical report remains as expert evidence and it is not opposed by the appellants. Thank you.
Before I give my final judgment, I have one question for the appellant's counsel and one for the respondent's counsel. For the appellant, what evidence directly supports your claim of collision among the respondents? For the respondent, does the lack of visible damage not weaken your case significantly?
In addressing the question, my Lord, the key evidence supporting the appellant's claim of collision is the absence of damage to the first respondent's motorcycle, as shown in the photographic evidence, and this directly contradicts the respondent's claim of collision. The respondent's failure to provide further evidence, such as repair records or additional photographs to explain this inconsistency, invites an adverse inference under illustration G of Section 114 of the Evidence Act, which allows the court to presume that evidence which could be and is not produced would, if produced, be unfavorable to the public visible domain. Furthermore, the improbability of the narrative, coupled with the lack of physical evidence, suggests that the respondents may have fabricated the collision in order to file a fraudulent claim. So under Section 10 of the Evidence Act, their actions in furtherance of this claim can be admitted as evidence of conspiracy. Thank you.
In addressing your question, my Lord, the lack of visible damage to the motorcycle does not weaken our case significantly because the medical reports authored by qualified professionals provide reliable, unchallenged evidence of injuries consistent with the collision. Under Section 45, subsection 1 and Section 114 of Evidence Act 1950, these reports are presumed credible unless proven otherwise, and the appellants have not provided any evidence to discredit them. As such, the Sessions Court judge had correctly relied on the medical reports in delivering his judgment. Thank you.
After reviewing all evidence and submissions, this court finds the Sessions Court judge acted correctly in relying on corroborative evidence and consistent testimony. The issues raised, including delays in reports and the absence of visible motorcycle damage, are insufficient to overturn the decision. The appeal is dismissed and the Sessions Court ruling is upheld. Thank you.